Remember folks, violation of specific safety requirements. The key word is specific, and Ohio courts are going to strictly construe these VSSRs in favor of employers. And you could see this most recently in the Supreme Court decision in State Ex Rel Cobbler versus the Industrial Commission of Ohio. And I'll put the site under the video, but essentially what ended up happening was this individual walked into this pressurized elevator, and unbeknownst to everyone, it had been flooded with nitrogen. And as this worker went into this elevator, there was there was little to no oxygen to breathe, and then he, died. He basically suffocated. And so he filed for a VSSR, and basically he was citing the statute, or the Ohio Administrative Code 4123-1-5-17F, which deals with respiratory protection, and then 4123-1-518C, which deals with control of air contaminants. And the issue was, so the SHO just determined that under the interpretation of the statutory rule at the time, those OAC codes at the time of his injury, nitrogen was not defined as a toxic gas. And so because there's nitrogens in the air, we breathe nitrogen, and so nitrogen is not a toxic gas. And also they ended up also having an expert, like an expert in gases, and that expert said, hey, nitrogen's all over the place, it's not toxic, et cetera, et cetera. So the staff hearing officer had some evidence to decide that nitrogen was not a toxic gas. Now, you might be asking, well, that's fine, but what about the fact that there was an excess of toxic gas? So what if you have too much not excess of toxic gas, but excess of nitrogen gas, i.e. the nitrogen gas had basically filled this space and there was no air to breathe, there was no oxygen to breathe. Does that not become toxic in nature? Like too much of a good thing or too much of anything becomes a poison or a toxin? And that's kind of what, when the injured worker's attorney, and this would have been a death benefits type situation, because obviously the guy's dead, so it would be his widow that was filing this. But they filed an appeal to the 10th District to a mandamus to overturn the decision of the Industrial Commission. And the 10th District kind of took that position of, hey, maybe nitrogen as construed by the statute at that time wouldn't have been, maybe if you take it in excessive quantities, maybe it becomes a toxic, or maybe common sense says that that would be a toxic gas, or like an air contaminant. Like if you have excess of nitrogen, that would be toxic, and therefore there should be a VSSR. And then, so what ended up happening is the employer, they filed an appeal to the magistrate's decision or the 10th District's decision to the Ohio Supreme Court. And the Ohio Supreme Court determined that based upon the definition of the statute that was being applied at the time, the OAC, the Ohio Administrative Code sections that were being applied at the time, nitrogen is not by definition toxic, and the code section doesn't address quantity or displacement of oxygen as a reason why something would or would not be a toxic gas. And therefore, since it's not defined as a toxic gas or contaminant, there is no VSSR. And the reality is that is how courts and the Industrial Commission typically construe these VSSRs. They're very, very, very pedantic, and you've heard the video where I talked about the person who destroyed their hand, And the issue was they were found not to be authorized to use the machine. And since they weren't authorized to use the machine, there's no VSSR. And so with these VSSRs, some folks equate, oh, I've had this horrible, horrible injury. And since I had this horrible injury, clearly this is a VSSR. And it's not, violation of, or a work injury that results in a horrible, conditions, or an accident at work that results in horrible physical conditions. That's not, it's VSSR specific safety requirement. So a lot of these things, it's either going to be on or off. Either there's going to be a VSSR or there's not. And it's not a lot of, with some of these things, there's room for lawyering. There's room for, squeezing around and arguing. But with VSSRs, a lot of times, they're going to be very, very, very strictly construed, and they're going to use the plain language, and they're going to use every word in that whatever OAC code section you're stating was violated. They're going to look at every single word in that whatever code section you're citing to. And as you can see with this one, I mean, that's kind of a signal to you with how the Supreme Court is going to interpret the VSSRs. They're as strict as you can construe every term in the statute. They are going to do so. And you could see it, again, this is a horrible thing to happen to this individual. And it's tragic. Somebody died, but it is what it is. Now, obviously, this guy's claim was allowed. So his death benefit claim for the widow was allowed, but the VSSR was not. And so what can that mean? Well, you'll get death benefits as a survivor. You'll get death benefits, death benefit claim. But with a VSSR, that would result in an extra tranche of money that person, that dead loved one could have used to, pay for their children's upbringing, education, these sorts of things. And then you might be like, well, can they file an intentional tort? No, not in this instance, because it was a malfunction in this, I guess it's called a pulse cleaning system. So that was unknown to the employer. So an intentional tort requires that they have knowledge of a substantial certainty that the injury is going to result, and the injury results in the manner that they had substantial knowledge of. So they had no awareness of this pulse cleaning thing. So if that's not there's no intentional tort there, and then you can't sue your employer for negligence for workplace injuries, because your sole remedy is workers' comp claim. So nevertheless, horrible outcome for this person, that they died. But it just gives you a little bit of a hint. This is absolutely how Ohio is going to interpret these things. So nevertheless, if you have had a serious work injury, you should always get a workers' comp attorney, but you might also ask your workers' comp attorney, hey, can you look to see if there's a VSSR implicated, a violation of a specific safety requirement? Because there may be, and that's just another form of compensation that you might be entitled to. You see these a lot, violation of specific safety requirements with like guards being removed and these sorts of things. There's some kind of blade or some kind of stamping machine, and they have had a safety feature them removed. So anytime you have some kind of equipment that results in like a limb being cut off or smashed or whatever, you should look to see if there's a VSSR. Otherwise, if there's something unique twist to the injury, there may be a VSSR, but again, there may not be, as you can see in this situation. So, as always, if you have any questions, concerns, etc., by all means, call or email me, and I'll try to address those if I can. Otherwise, if you have a work injury, by all means, please consult with an attorney or multiple attorneys. And I'm always going to recommend people get an attorney involved in a workers' comp case. It's going to pay dividends, but at the very least, consult with somebody. Please stay safe, everybody. Thanks for watching this and listening to this video.